Good day and welcome to the review of the Discrimination in General chapter, which is in Chapter 14 of the SHRM Essential Guide to Employment Law by Charles Fleischer. The first significant non-discrimination law, Title VII of the Civil Rights Act, was passed in 1964. This law deals with discrimination in employment and public accommodations. The law was amended in 1991. Title VII, a cornerstone in the fight against employment discrimination, extends its protective umbrella over an employer with 15 or more employees, employment agencies, and labor unions. The broad scope ensures comprehensive protection for all. The Equal Employment Opportunity Commission created Title VII and is responsible for enforcing it. Please read over the portion of Title VII that is found on pages 280 and 281. Reverse discrimination is when a non-minority member is discriminated against in favor of a minority member. Please read over some cases involving alleged reverse discrimination that are found in this section. Two other essential terms in this chapter are disparate treatment and disparate impact. Disparate treatment is when an employer intentionally decides not to hire someone because of race, color, gender, or other characteristics. Disparate impact is less overt. It could be seen as policies or education requirements which have an adverse impact on a particular group. As we said, Title VII prohibits discrimination in hiring, firing, compensation, and other terms, conditions, and privileges of employment. Some examples of conditions and privileges of employment could include vacation, insurance coverage, and even access to fitness centers. Our chapter talks about bona fide occupational qualifications, which are legally allowed restrictions in employment. An example would be a mandatory retirement age for airline pilots. Please review the covered employers and employees section that is found in this chapter on pages 283 through 284. We have discussed independent contractors in previous lessons, but remember that if an employee is misclassified as an independent contractor, according to our author, this is as disastrous for non-discrimination law purposes as it is for tax and benefit entitlement purposes. Title VII makes it illegal to discriminate against an employee based on religion. However, based on the First Amendment, the courts have developed the ministerial exception. The employer is also not required to accommodate a religious practice if it poses an undue hardship. Employers are also not required to give employees off Sunday or other Sabbath days. They can try to accommodate, but it is not a requirement if weekend work is necessary. Please read over the examples of other cases of possible religious discrimination that are found on pages 291 through 294, including the section entitled Genetics. Title VII also prohibits retaliation against an employee who has brought up a discrimination complaint. The Supreme Court has said that the retaliatory acts must be material and adverse. A retaliation claim includes an adverse action because the employee engaged in a protected activity, like filing a claim, participating in a discrimination proceeding, or serving as a witness in a proceeding. Please review the steps to a Title VII case, which include investigation, notice of the charge, probable cause, remedies, and after acquired evidence. Although Title VII is the most significant federal non-discrimination law, there are others, such as Section 1981, the Immigration Reform and Control Act of 1986, discrimination laws protecting military service, and protecting financial discrimination. Please note, most states and local governments also have non-discrimination laws. Remember also that most professional groups prohibit discrimination, and those who discriminate will be subject to discipline. This concludes our review of the Discrimination in General chapter. Have a wonderful day.